Good morning. It is 10 a.m. We don't yet have a quorum, so we're going to wait a couple of minutes to call to order this meeting of the Public Safety and Justice Committee. It is good, thank you. Good. All right, now we will call to order this meeting of the Public Safety and Justice Committee on Tuesday, September 20th at 10:01. And Colin, would you begin by taking a roll call, please?
Vice Chairperson Chavez. Here. And Chairperson Ellenberg.
I am here as well.
We have a quorum. Thank you.
Thank you very much. Sorry, pulling up my agenda here. Thank you very much for that. We will begin with public comment. This is the portion of the agenda set aside for members of the public wishing to address this committee on matters not on today's agenda, but within the purview of the Public Safety and Justice Committee. We will take speakers first in chambers and then on Zoom. Colin, do we have any speakers this morning?
There are no requests to speak in the room, but we do have a request to speak in Zoom.
All right. How many requests do we have on
We
Zoom?
currently have one request to speak.
All right. Noting for anyone else on Zoom, if you're intending to speak on public comment, now is the time to raise your virtual hand. The queue will close when the first speaker begins speaking, so we'll give that a few seconds.
Still one request.
All right, then let's offer that speaker 3 minutes, please.
All right. Their next request to speak is from the user identified as resident. You'll have 3 minutes to speak. Please accept the unmute. You have 3 minutes to speak. The timer will start when you begin speaking.
Hello, good morning. I wanted to address this committee because my kids are being sexually abused. I've gone to the police, I've gone to the district attorney, and nobody is willing to help me. And the thing is that my former attorney is sex trafficking my kids. And the district attorney has a conflict of interest with this attorney. And I told him personally, I told him all the details, and the district attorney, I was sure that he was going to do something. I was 100% sure because, I mean, that's his legal mandate to do something to protect kids in that sort of a scenario. And instead of doing anything to protect them, Mr. Rosen went ahead and he filed charges against me with the intention of quickly bringing the matter to competency hearings and to discredit anything that I said. And when I refused, I was repeatedly assaulted by this attorney when I refused to take part in any kind of evaluation. And still, I kept reporting all the information about all the assaults and what it's done to my body. And the district attorney kept going with the proceedings like, you're going to die or your kids are getting raped. And it's just completely unacceptable. And I've brought this up numerous times to the Board of Supervisors, and they refuse to do anything. Supervisor Chavez told me at the last committee meeting that I attended, she said that she would get back to me or staff would get back to me, and nobody got back to me, and that was over a month ago. And I posted all the details. If anybody's interested, if you Google Jeff Rosen petition, it'll be the first result that pops up if anybody wants to see it. And what I'd like to do is, again, if there's anybody at this meeting or anybody on this committee that can talk to Mr. Rosen and ask him, and please don't let kids get raped. I mean, it's that simple. Don't let kids get raped. Go protect my kids. Do something. go send somebody to see what's going on. My son has already confirmed that my ex-wife let somebody rape him. And all the other kids are showing signs of being sexually abused as well. I mean, you got to do something. Instead of letting this stupid attorney, sorry for saying stupid, assault me. I mean, it's just terrible what's going on in this county. Please help me.
And that concludes our request to speak.
Thank you very much. Approval of the consent calendar is our next item of business. We have two items right now, 11 and 12. Supervisor Chavez, do you have any changes you'd like to request?
No. I'll move approval.
I will second that. Do we have speakers on the consent calendar?
There are no requests to speak in the room nor on Zoom.
All right, let's vote.
Vice Chairperson Chavez
Yes.
and Chairperson Ellenberg.
Yes.
Motion carries. Thank you.
Thank you very much. I just want to make a couple of quick notes about our regular agenda, which is very meaty today, particularly the items 4 and 5. I anticipate a good deal of conversation. So what I would like to propose, and we can certainly be flexible, is that we aim for 30 minutes or a 30-minute cap on 4 and on 5, which would give us time, in theory, to get through the rest of the agenda. If the conversations are in full force and we don't want to stop at 30, we will absolutely keep going. I just want us to be aware of the time. And if necessary, I would recommend holding 8 and 9 to our next meeting, again, if necessary, depending on the time. Does that sound all right to you?
Yes, it does. And I wonder, Chair, if it's appropriate, and I don't know if it is from your perspective, but to hear 4 and 5's presentations together, and then hear 6 and 7's presentations together, and then allow for questions and conversation with everybody after hearing both of them.
I think that's fine. So we will hear 4 and 5 together, so one presentation after the next, and for members of the public wishing to speak on either 4 or 5, we will ask for public comment after the staff presentations and before the dais discussion. So I believe we have Judge Yu to present. There you are. Come on down.
Yes,
Absolutely, please do.
We let judges sit wherever they like.
Fair point. But let's wait until you get your microphone on so we can all hear you, please.
Good morning.
Good morning.
I invited Dr. Oliveras to sit with me in case there were questions. And I didn't think this would take too long, but I'm happy to answer any questions. I prepared a report, and I felt that the voices of all the people involved were very important, so I tried to capture all of those voices. It ended up being rather long, so I'm sorry for that.
It was fascinating.
It really was.
Good. So we're here today to ask if there's a possibility of having a housing navigator in the courthouse. It would be really great because it would support not only the calendars that are in Department 62 and 63, which remains vacant, but also it could serve the people who are in Department 60 and 61. We did have some housing navigation, but the grant is over, so we really do need someone who knows about housing to help people. As I mentioned in the report, it'd be great to have case management, some type of case manager. And then, of course, probation is telling me that they would need more bodies or more staff because the YADEJ calendar is expanding. We started out as 2 half-days a month. Now we're 2.5 full days a month. And we're, as Mr. Brandon Cabrera said in his camp report, the YADEJ statute now allows people up to 25 to be in the program, and we're adding people kind of as we go. We're kind of checking to make sure we don't get overwhelmed, because hundreds of people can be added since the age requirement went up. So probation is understaffed right now for YADJ. And then finally, I know the county is working on trying to have more capacity for treatment. I've never been to this committee, so I watched the August tape. And it was interesting because in August, there was a discussion of how the crisis residential beds get full, and then you need to get those people out and put them somewhere else. So what I'm seeing in the courtroom is when I'm ordering a continuum of care of crisis residential, SUTS residential, and then some type of SFP program, if the person has finished crisis res and they're done, there's no place for them to go to SUTS, so then they go to an SLE or boarding care. And I have some concerns about public safety. Most of the people I have are felonies. They're felons who are charged with some very serious things, including stabbing people or, Estes robbery, where they're assaulting a security person who's trying to stop them from shoplifting. So there's actually really injuries, there's victims. The misdemeanants probably would be more likely to be out of custody. So the DA who's in my courtroom and myself and the public defender or the people from behavioral health are talking about what the plan should be. And I actually look at all the police reports because sometimes these people have multiple cases, and I'm looking at their criminal history. So when I'm releasing them, I'm thinking they're going to have a whole continuum of care. But if they only spend 2 to 3 weeks in crisis res and then go somewhere there's no real supervision, there's not really a reflection of the matrix and the thought process that's going on in the courtroom to keep the public safe while these people are being in treatment. So I wanted to just highlight that as something that I learned about in the August meeting. I'm seeing actually happen in practice and is a concern, I think, for public safety. So I'm happy to answer any questions, and Dr. Oliveris is here to answer any questions.
Thank you so much, Judge Yu, and thank you for Dr. Judge, and thank you for highlighting one of our most significant challenges, which is the capacity of our mental health and substance use treatment services. Let me first just make an overall thank you and acknowledgement of really the incredible visit that I had recently in Department 62. It was really a very eye-opening and inspiring experience to hear so many success stories of individuals who are involved in the criminal legal system during my visit there and as well in the report here. And I know we'll talk more about some of the specific programs, but what I saw and what I both appreciated and also lamented because of its rarity is really the deep care and the human-centered work that your department has, that you have innovated and carried out. It's really telling that a lot of the success has been really just exponentially expanded over the last 5 years, and it's a model really of what I would love to see all of our courts doing. The entire concept of collaborative court just makes so much basic sense. I realize that it is very labor intensive and time intensive, but if we are measuring based on outcomes, and really that is the only measure that we should have, this is, to me, the model that we should do this, that we should employ in every court. But of course, given the resources and support, Judge, how do you think, Amity, that this can be expanded? What is the reality? Because I imagine it's not simply that nobody else wants to do this. What do we need to make this model department the norm rather than the exception?
So I very much appreciate that question, and I do want to also echo what you said. Judge Yu is a trailblazer. As you can see from the comments in the report, She is what makes a big difference in that courtroom. There are others, of course, who want to do this work and who are also very talented and good at this work. But she has really, it is true what the report says, which is many courts have gotten rid of their collaborative courts. And so Santa Clara County has always had, not always had, but for a very long time has been committed to collaborative courts, and we remain committed to that. But we can remain committed to it because people like Judge Yu will actually say, okay, I'm going to make this work, even with very limited resources, despite the sort of time and dedication it requires by her, over and above what are typical court hours. And so that's how it works. So in direct answer to your question, though, our challenge is, and we're at the time of year when we look at what 2024 is going to look at like. I know you've heard these numbers before, but I'll say them again. The courts are funded at about 91% of the number of courts any court is deemed to need. That's based on a statewide look at what we call the judicial needs assessment. There are challenges, I think, with that calculation, but nonetheless, our funding is based on that. The statewide funding model says that we should have 62 courtrooms. We have 82 judicial slots, and historically had 82 judges working, absent judges who are out on leave or retiring. So our reality is that at the moment we can run about 63 fully staffed courtrooms based on the funding that we have. So we are trying to meet the needs of so many different requirements. We have to reduce our criminal court backlog. That's been a big challenge this year. That's been a big focus this year. The civil backlog has grown because we were focusing on other things. Of course, we have the obligation to meet our needs in family court, juvenile dependency court, juvenile justice court, et cetera. So that's our challenge, is sort of balancing all of that. Judge Yu has advocated and quite persistently, as she should, for additional time in her courtroom, and some of that is being granted. Is it enough? Probably not, but on balance, it's really what we can do at the moment. So the short version of all of that is more funding for the courts would result in more collaborative courts.
Thank you. One of the survey respondents in the report proposed that a designated collaborative court coordinator or liaison could be helpful in ensuring that the current collaborative courts model that's in place will continue in the future or facilitate expansion within our existing courtrooms. Is that something that you think is a good idea?
I do, and there are other examples of that. There was a period of time when we had dependency court, family court, and the family violence court had sort of a unified courtroom, and they had a coordinator, and they made a big difference having that coordinator. So yes, I would say that is, I liked that suggestion as well. I think it's a good suggestion. I would also echo, I want to add just one other thing, and that
Please.
is, I'm in the family violence assignment. I do send a fair number of cases to Judge Yu. The capacity issue, and I know that is something you all are struggling with, that really is a big issue. Because if we knew that we had safe capacity as well as that transitional piece that Judge Yu was just talking about, then we can safely send domestic violence cases there, which are often family violence cases, which often involve children and their parents, right? Where there's a serious mental health issue. So it is, I would agree that the safety factor coming out of residential and then into something else safe is a very important factor.
So thank you so much for that insight. And if I'm thinking really pragmatically, to be able to inform the board's ongoing conversations around bed capacity, do we have data on what levels of care have the highest demand specifically from the justice-involved population?
We do, and it is crisis residential. Our intensive FSPs, our intensive forensic community assertive programs are the highest utilized programs right now.
So 2 of those are outpatient,
Correct.
and 1 is inpatient.
Correct.
And do you have trouble placing people in the outpatient? Is it a staffing shortage, or is it just the inpatient beds?
No, it's a staffing shortage with some of our community-based organizations who also.
It's a little bit hard to hear you. Can you go
It's
closer?
a staffing issue also with our community-based organizations that are also struggling to find clinically licensed clinical social workers, case managers. Yeah, it's a staffing shortage all over the county.
think we hear this in every single context, in every a single meeting. It really is striking how broad the impact is and how really catastrophic the domino effect is on all of our systems. Thank you for that. On the housing and case management, Judge Yu, regarding the need for a housing navigator, I'm curious if this need is one that's separate from the need for expanded case management generally, such that we would need a dedicated housing position, or do you envision that being an additional service provided by a case manager?
I think that we need a designated housing person because the housing piece is so complicated, which is why our division and I organized a housing training for everyone so we could understand it. And what we found out is we really don't understand it because everyone is so different. They all have different needs. So there's this wonderful woman named Jessica Roscoe who works for the Office of Supportive Housing. She will let me email her, but she doesn't want to be inundated by clients. And I'll say, this person's in custody. They're worried about losing their housing with Abode. What can we do? And then she'll email Abode, and she'll try to let them know that this person's in custody, but the housing can only be held for a certain number of days. So we need someone who's there who can coordinate. Also, I know our population is transient, and so often they actually have some housing available to them, but no one can find them. But they come to court. So when we try to coordinate and say, I can say, oh, I have this person now, and Jessica will say, what's their phone number? Let's get them, connected. But by that time, the house is already gone, or the, studio's already gone because it went to someone else. So if we had someone at the courthouse in the court team, when the person shows up, they could look them up. So when we started Family Wellness Court, we actually had someone from Victim Witness, and we put a dedicated confidential computer for her in the courtroom, and she could look up whether or not people had funds left for therapy. So I'm envisioning if we had a housing person, they could look up everyone in the calendar in HMIS and say, oh, this person has an opportunity. They're going to be here today. Let's close that loop and get them into the housing, as opposed to the housing people can't find them because there's just not enough connection where people do come to court.
Yeah.
So I think that's something different than what a case manager would do. A case manager would be able to connect them to employment services, housing services as well, furniture once they get the housing, things like that.
Sure.
So they're two distinct things. And I definitely think that if there's capacity to keep this going, we need to fill in 63, and I know the court is trying to do that, because we can take more people if we had another courtroom going at the same time. But it's complicated because we don't have the staff. But I can retire in 15 months, so I feel like a sense of urgency to make these things happen. Because when I started in this collaborative courts, there were no assessors at all, no such assessors. Judges were buying bus tokens on their own, and I was going to the dollar store buying reading glasses and all sorts of care packages things. And now we've got so many things through behavioral health, MHS linked, just a lot of things. And there are things that I'm going to be working on in terms of addressing the Medi-Cal issue, the Kaiser CSRs. I have a lot of plans, but I only have 15 months. And so I just really want to try my best to get things in place so that when I do retire, someone else can fill in, and there'll just be all these things present as infrastructure to serve these really deserving people who have been bereft of so many things throughout their life.
So, yes, consider us all on high alert for 15 months. I can feel the up here. And also, I just want to quickly note how much I appreciate your commitment to continuing infrastructure, because I think so often our leadership really is only as good as what continues after we are not in those positions anymore. So thank you. And you referenced the MHS linked program provided through reentry. And Javier, I'll turn to you. To my understanding, both the navigators at the RRCs and behavioral health programs typically provide referrals to housing. So I was a little bit surprised that MHS linked doesn't have housing connections. Is that something we also need to be getting started?
Thank you for that question, and thank you, Judge Yu, for identifying MHS Link serves as one of our partners. All of our service navigators, there's 4 plus, or there's 3 service navigators in our 4 faith-based centers. All their staff are trained to do HMIS. And so their part of their case management is also looking if they have been in the housing queue. Now, of course, one thing is an assessment, referral, but the actual placement.
Right.
And as been reiterated in this document and also in the future documents, housing is an issue. So our housing program, just for reentry, was reduced by 15 slots from last year to this year. So we're hoping, we're working closely with Office of Supportive Housing to see if we need additional funding for that.
Yeah,
MHSA Linked is unique because they have a housing component in their contract. But like Judge, we would all love to have dedicated housing navigators at each centers. We have one Office of Supportive Housing community worker at the center that looks individuals up. But unless there's actual housing, our clients are frustrated because we don't have that connection. So MHSA Link with all of our navigators are looking for motel vouchers, sober living environments, and more of the temporary transitional housing.
Thank you. And is it correct that you only have funding services for 6 months?
No, so
Oh, good.
with
Okay.
the contract with MHS Linked, they could see the client up to a year.
Okay.
The average by default is 6 months. So we're always looking at seeing if a client needs to be discharged in order to have more additional clients to be case managed by these service navigators.
Yeah, thank you. And I'm thinking also about the bond that the governor has proposed to put on the ballot that would focus on specifically mental health related housing, both locked and unlocked, may be a really positive opportunity for us to create more of our own, because I think that's what we're going to have to do. It's very hard, even if the slots and beds are available, to sometimes have private providers be willing to take some of the higher needs clients. And while I have a whole list of concerns and comments that I won't share about MHSA shifting funding as opposed to adding funding for housing, I think ultimately these are things that we're going to be able to make really good use of. Of course, that's a little bit longer term than we need right now. And of course, these gaps that you're referencing have been identified really across county departments. And so I'll look, Casey, to you. I know Greta is at the leadership training today. I'd be interested, in addition to case management for the reentry population and housing navigators in the courtroom, I'd be interested in having administration take a closer look at the gaps in case management in the dependency wellness and family divisions, the limited capacity of FLY, and really full support for SUT litigants. And I would like to ask administration to prepare an off-agenda report for the board that identifies reasons for the gaps in case management that were identified in this report, and some potential solutions, as well as options for providing housing navigation to our collaborative court litigants. I'll make that part of a motion.
Okay, I have a little different perspective on that, but yeah. I'll second that for discussion.
That's fine, and I am absolutely happy to amend and improve on that. Let me go back to Gabby Olivares for a moment. What are the funding sources for assessors and support staff, and are they behavioral health staff, or are some funded through the courts or other programs?
They're all behavioral health employees, and mainly their funding source is Mental Health Services Act and some diversion funding that we get through the Department of State of Hospitals.
So some of that forensic diversion
Correct.
and reintegration team, I know that's one of the many that had vacant codes that we weren't able to fill, and so they were cut in the last budget cycle. Do you know where any of those vacancies that were cut assessors positions?
We did reinstate one position, and we actually have 3 interns right now to try to attract more of the workforce to come work with this population right now.
Oh, good. So we're looking,
Can I just
Yeah,
ask
please.
just a quick question on the assessors? Are they clinicians?
Yeah, they're clinical licensed social workers.
And do they need to be clinical licensed social
They
workers?
do. They
Based
do.
on
Why?
what? Jinx, you owe me a Coke.
Based on our recommendation to the court and having sometimes to put people on a 5150 in court when they're clinically not well, and to do a full comprehensive assessment.
Okay, I have just, thank you for your patience here. I just have one more question. It sounds like Supervisor Chavez is going to circle back to that. Regarding the request for probation staff to support the expansion of YADEJ, look, Marielle, can you speak to where the probation department is on this staffing need and whether you're planning to reallocate existing staff or submit some budget requests for expansion at the midyear?
Thank you. We currently have 3 full-time deputy probation officers who are assigned, and we have, in August, we had 95 active cases. Those probation officers are at capacity. We have 1 other FTE in that unit. Unfortunately, that person's out on a leave. So we're looking at a reallocation of staffing. I think in general, as the age increases from the current age range to 21, from 21 to 25, we will be looking at all of our APD needs for redistribution of caseloads. So that is something that's actively going on within the probation department today, and we plan to make some changes. We have not yet determined if a budget budget request is necessary to address that, or if we can do that internally.
Thank you so much. And before I turn to Supervisor Chavez, County Council reminded me that we'll need to take, we didn't in fact hear 4 and 5 consecutively because there's just so much, but we'll need to take public comment before we vote on the current motion on 4.
So first of all, I've got everybody's titles confused today. Judge, you, and to the entire court, and really to all of you who work in this collaborative environment, it's really amazing work that's being done and absolutely should be expanded. And I had many of the same questions that President Ellenberg did, but here's the recommendation I would like to make is that instead of getting an off-agenda report, what I would really like to see is an assessment from all of the different departments that are impacted by the report you put forward, and have that actually come back here to say, here are the recommendations that we think need to be made. And the reason that I'd like it instead of off agenda to actually come back to the committee is I think it's really imperative that 3 things happen. 1, that we hear from all of you about what parts of this can be advanced and lifted up in a more robust way. 2, I also think that we have an opportunity to perhaps rethink what the next phase of expansion is. And what I mean by that is that, right now, and I haven't gotten an update, but the reentry center was presumably going to be a place that we were able to bring people pre-booking and be able to start to address them relative to mental health services and other services. And what I am mindful of is that that we have a lot of parallel paths that have areas that should be crossing over that really require us to think in a more rigorous way about what expansion looks like so that in fact it can be sustainable. So that's why I'd like it to come back here. And then the third, let me just add the third bucket to that is that there are some areas here where I thought, oh, that totally makes sense. And others I thought, well, it probably makes sense, but I don't know how the dominoes fall. So this brings me to the last issue around sustainability and even staffing. So like I was looking at the assessor category and wondered, and I presumed it needed to be a clinician. And then I was thinking, well, why wouldn't we look at having a clinician supervise folks who may not be clinicians? Because I frankly worry that we're never going to be able to staff up in the areas that we're trying to. And I think that we're going to have to be really judicious about under what terms and conditions we're using paraprofessionals or other kinds of leadership in order to really start to address this. And then just as part of that, I'm also very concerned about us not following the direction of the court by putting people in placements they are not supposed to be in. And I think, you know, Judge, you raised that. So anyway, there's a lot in here. So I'd much rather have staff that are impacted sit down, strategize, and bring this back saying, here are the fixes, here's what will have cost, here's what we don't think we should do, and here are the implications to our expansion. And just because I'm always thinking about budget, as Susan reminded me yesterday, and that is that I am also mindful that as we are rethinking how we're going to approach budgeting, you know, under this, both under a new county executive, but I think under your leadership, Susan, I think we also have to take a look at where we can get matching funds for what kinds of staffing, and that should be driving a little bit of our direction as well. And I'm thinking particularly about that as it relates to probation and other parts of the organization that may allow us to get an appropriate level of staffing, even if it's not the exact staffing that we're using today. So anyway, I'd rather it come back.
Deputy Executive Casey Halkin wants to weigh in, I believe, on that.
Yeah, and it's a little bit with an old hat, but I worked with Judge Yu when we had victim witness in the courtroom in my former role. And in talking about case management, I think I would be remiss, and the committee itself, not to consider when we think of justice involved, we're often thinking of the reentry population, but I think we should also consider victims and their families, because they also need pretty significant case management, and some of the same underlying criminogenic factors need to be addressed for them as well, including housing, mental health care, and supports. And Judge Emity was talking about, you know, the way that we handle our family violence courts and our domestic violence courts. You know, you work in criminal justice, and the line between victim and offender is blurred and gray on any given day. And the reason why I bring that up is as we're thinking collectively about caseloads, case management, and how we're moving people through the system, I do think we should consider the needs of victims and families as well. And I wanted to see if the district attorney's office may have some comments about what the current caseloads are for some of our victim advocates, particularly for our more sensitive populations, like those serving our child victims, and also our family violence cases as well.
Sure. Last week, we posted on our website a report that is actually really, I think, complementary to the report, Sheriff Johnson, that you're presenting later today about the statistics from the Sheriff's Office about crime in Santa Clara County. And one of the things that was dramatic about it is the increase in reported sexual abuse and domestic violence in our county over the last few years. And I think Casey's point is really well taken, is that the trauma of being a victim of crime and the needs that victims of crime have, child victims of crime, victims of domestic violence, adult victims of sexual assault, and other victims of crime, are something to be thinking about when we're talking about justice involved. And it's about the caseloads. Judge Emity and Judge Yu referred to the backlog, and it's a challenge. And one of the challenges of the backlog is a challenge that Damon and our friends at the Public Defender's Office are facing, is that all the people working in the criminal justice system have more cases, and that also includes our victim advocates, both in the DA's office and victim advocacy services with our CBO partners. So I think that's an important point to raise, and I'll just end this comment by saying that in this context, we also have the specter this next federal fiscal year of reduced funding for victim services from federal dollars that gets passed through to the state to victim groups like DA Victim Services and our CBO partners. The proposed funding cuts in the federal government are possibly going to be as much as a 40% cut in federal funding. And so I think that we'd be thinking about those impacts as for the criminal justice involved families who are the victims of crime.
So from my perspective, that this is a very important discussion, but I want to distinguish it from the discussion we're having today, in part because we're speaking very specifically about the courts, and I think about Judge, you're 15 months, so I'm a little focused on you right now. I think the issue that that was just raised is one that is worthy of a discussion and should be agendized specifically. The one reason I think there is that there is some urgency, and I would really just share this through both Dr. Luna and Casey, is that the cuts to the Violence Against Women Act. I mean, it's astounding to me that anybody in the world thinks that's a good idea, but it is going to have a dramatic impact on service provision here at a local level and across the country. And so I am mindful that that's something that really should be agendized either here or for the full board's discussion, and would request through the president that that's a discussion that perhaps you have with Greta, and then you can decide where you want to bring that back. And then the other discussion should be agendized for a separate item.
Could I speak a little bit about the victim aspect? So we had someone who was on for pretrial release because of his mental health needs. He had burned down a house that he was living in with his sister, and his niece was like 8 or 9, maybe younger, was completely burned and wouldn't go to school, and then the sister became homeless. So because of the collaborative courts, and we have truancy court and housing, we were able to help that victim try to get housing. And then because they were homeless, we implicated McKinney-Vento, and then we got the little girl to school. So there's definitely aspects of where this collaborative court is serving the victims. Most of the domestic violence or intimate partner violence or family violence cases that come from Judge Emity and her colleagues are successive violations of restraining orders where it's the parent who is the victim of a child, an adult child. And the assessors are great because they actually will speak to the parents who are the victims and kind of guide them also to their own mental health services. And NAMI also comes in the courtroom with those victims. So I really do see that there's a place for so many different healing points in a collaborative court, because people just, I mean, they bring in everything. They're not siloed. And so if we think about how we can serve victims as well, I think we're doing some of that, but of course we could always buttress that with additional services if they're available.
Yeah, and I would just add, I know that that there's an extraordinarily high percentage, and Casey will tell me what it is in a moment, that of people who are victims of crimes who are already part of the criminal justice system. So the only reason I'm requesting the distinction is just from a time perspective, but I do think we all understand that those are issues that need to be addressed. And to be frank with you, I'm not certain that, again, I think this is a model issue as to whether or not we have a current model of serving victims that is going to work for the next 5-10 years. I think we're still using, that's to me an area where we've had excellent service, but a relatively older model. So something for us to take a look at in the future. So anyway, I don't know how you feel about having it come back to committee instead of an off agenda.
I'm actually delighted with that. I think that's great. I just want to ask one additional question, Javier, that occurred to me when we were talking about housing so much. When we were allocating ARPA funds way back in November of the dark ages, there was an allocation, I think, of around $4 million for reentry, and we talked about that with regard to housing. And then at some point, I recall hearing that that wasn't needed or wasn't needed for housing. I am absolutely delighted that we are doing the reentry guaranteed income pilot. I know that that has some ARPA, some AB 109 funds, but either did we miss a window for reentry housing, or are there should still be ARPA funds? Is this a place that we should be looking again? I was surprised.
So I believe the last report from the administration to the board on the ARPA, it did indicate that the ARPA funds were not eligible, or that reentry housing was not eligible for ARPA funds. So we would
Really?
then
That's what it was?
look at our existing AB 109 funding for reentry housing. I think there was a few items
It sounds
on the
vaguely
ARPA
familiar.
matrix that were identified as no longer eligible for ARPA funds.
No longer eligible? Is it, Casey, did you?
We had Martha Wipensky in the audience who
Excellent.
can speak
Thank
to this.
you. Hi, Martha. Yes. Where's that money?
So with the Finance and Government Operations Committee will be hearing it
That would be
this
me.
week or next week. With the particular housing funding that you're talking about, within the entire bucket of the 374 million for ARPA, things were moved around within those buckets. With the housing that you're referring to, there was conversations about different funding sources for that out of the Office of Supportive Housing. And so that money was reallocated within the larger bucket of ARPA money.
I'm talking about the 4 million that was allocated specifically for reentry. I don't recall it saying specifically housing, but we had that pot of money.
Right, and so we're going to be finding other funding sources, other initiatives that the Office of Supportive Housing is doing, not funding that particular proposal the way it's laid out with that particular $4 million.
But we have other resources because clearly we're hearing what a significant need we have for reentry housing.
Yes, and I don't have the level of details here with me today. When this goes to FGOC, I can certainly provide more detail.
Thanks. It would be great if you could plan to do that. Thank you. Damon.
Thank you. I had a question, I think, for both Judge Yu and for Gabby. Gabby, there was mention by Judge Yu regarding capacity for residential beds. And I'm just curious as to whether we see any sort of light at the end of the tunnel or on the horizon. I think in speaking to Mairead O'Keefe, our supervisor today of our mental health team, they were suggesting that maybe 47 out of the 100 people on the JAC list are waiting for a residential crisis bed.
Yeah, that is the utmost priority right now for the department. We've just received some CHAFA funding, $8 million. We're looking at some additional funding through the Department of State Hospitals. Most of those clients that are actually waiting on the JAC list that are going to crisis residential is that population, the DSH population. So we are looking at that. We just got all of our data files from 2017, and we're actually looking at the utilization, diagnosis, and what additional levels of care would be appropriate for this population. And lastly, what we're looking at, people have come back to crisis residential more than once. So we're expanding the stay of crisis residential now to 30 days, and we also are expanding medication. Right now, the contract reads 5 hours of psychiatric med time, and we're increasing it to 7. So based on our data, our analysis, we're looking at other avenues of expansion for residential and looking at the current structure and making changes to the current residential structure, again, to increase average length of stay to 30 days now, and psychiatric medication to 7 hours as opposed to 5, given the clinical needs of the population, which we're seeing people coming out of the state hospital a lot sicker than a few years ago.
That's encouraging. I know that we've been discussing it at the ATI group, in particular on reentry and the capacity, and I know that that's not necessarily a new issue, so that's encouraging. We're looking at alternative strategies. Judge Yu, this question actually may be better directed towards Supervisor DA Brandon Cabrera in the next presentation, but I noted in that their camp report in 2022 regarding the YADEJ, there was somewhere around, I think the list was 552 referrals, but 224 were found unsuitable. And when we're talking about expansion already, I guess my question is there a way that also potentially the suitability eligibility or the suitability number gets reduced with about a 50% rate now of people being found unsuitable, even under the current structure? Do you have any thoughts or insights about that?
Yes, and I can defer to Mr. Cabrera also, but when we started the YADJ program, we said that the DA's office would determine eligibility and probation would determine suitability. Very quickly after that, because it was such a new program, people weren't coming in. Brian Welch was wonderful, and he said, look, I'm taking off all the caps. Let's just make everyone eligible except for violent crimes. And so then probation now is the one that determines suitability. Jennifer Contreras is now the head of that unit, and she works so hard. She's really brought things back, because during COVID, things kind of were not so organized. But they're really looking at suitability, because before, when they didn't have Jennifer, they kind of let everybody in, and there were some people that maybe should have been in mental health diversion court, or just were higher needs than what was contemplated by the probation department. When the chief at that time went to the state and worked with Jerry Hill to have the bill passed. If the lawyers dispute the suitability recommendation by probation, they can always go to one of the felony case managing judges, and the judge can overrule probation's recommendation. I'm finding that currently the people coming into YADJ are really functioning well and probably should be there. Before, we would have people who were, during COVID, probation said, oh, everyone's doing fine, and then it turned out these kids were being shot, or they had been shot multiple times, and they were not doing so fine. So I think Jennifer Contreras is doing a really good job now in terms of suitability and supervision.
Great. Thank you.
Thank you. Let's see. Oh, Marielle.
Just one quick response to that is that YEDEJ is intended to be a lower touch program supervision. So while it's in more intensive services, it's lower touch supervision. And so suitability really is important to be looked at so that we don't have folks who need really intensive mental health services or substance use services in that program, but are better served in other collaborative courts.
Well, actually, can I add to that? The beauty of having the collaborative court is that I get them anyway, but they're not going to be YADJ. They're going to be pre-plea, or maybe they're ARC, but I'm still seeing them anyway. And then the other beauty of it is, if they are not able to successfully complete YADJ, they're put on probation, and then I see them anyway. So we've got a relationship with them already. We know who they are. We can still help them and work with them and get them through the process. That's part of the beauty of having a collaborative court. You still get to see them and work with them.
Thank you. All blew through the 30 minutes.
Sorry.
And then
No,
some.
that wasn't you. I blamed the president.
No. That was me. No. Of course it was me. But thank you. Let's do public comment at this juncture, then we will vote on the motion on 4 and then move to the presentation for 5. So this is public comment for 4 and 5.
There are no requests to speak in the room. We do have 2 requests to speak through Zoom.
All right, let's offer 2 minutes. And for those of you who are on Zoom, if anyone else wishes to speak, now's the time to raise your virtual hand. The queue will close when the first speaker begins. So Colin, give that a
All right, the next
second
speaker
or
is
two.
resident. Please accept the unmute. You'll have 2 minutes to speak. The timer will start when you begin speaking.
Hey, sorry, Colin, I just wanted you to wait a second or two to see if anybody else joins, since I just
We have
announced that we'll close the
one
queue.
more person for 3.
Okay, then. All right, so we will go with 3 speakers. Thank you for waiting.
All right, go ahead, resident. You will have 2 minutes to speak.
Yes, hello. Going off my first initial public comment, I think the first thing we need to do before we decide that we're going to fund mental health courts further is that we need to get out all the waste. And in my case, like I said before, my kids are being sexually abused, and mental health court is being misused to absolve the attorney, Valerie Houghton, my former attorney, of sex trafficking my kids. And the example of this is that a psychologist had submitted a report without ever meeting me, without using an empirically valid assessment. He used a report to say that my kids aren't being sexually abused without meeting with my kids, without knowing anything. And this is all being done on the taxpayer dime. And it's completely wrong. I mean, it's immoral, it's wrong. We all know it's wrong. And we should be rooting this out before we start saying we're going to throw more money at mental health courts, when mental health courts are being used to sexually abuse kids, or sex traffic kids is more accurate to say. And so I want to ask Mr. James Gibbons Shapiro, because he is the representative from the district attorney's office here. Can you please do something? Please, I beg you, can you please do something to stop this? can you please do something to help protect my kids? I mean, my daughter's been thrown to a rapist. By the district attorney's office helped do this. My youngest daughter, who's completely different from my other kids. And I mean, this is wrong. Please, Mr. Gibbons Shapiro, please help me.
Our next speaker is David Montiel. You will have 2 minutes to speak. The timer will start when you begin speaking.
Yes, my name is David Montiel, and Susan Ellenberg is a supervisor that serves me. Yeah, we're talking about these collaborative courts. Also, the gentleman before talking about some rape stuff going on and things like that. I mean, that needs to be taken seriously, and I really don't like the fact that Susan and Cindy were there talking halfway through. They weren't really listening, and I mean that's an issue that I've seen over the years. Is that when you bring something up, when you bring something up and they think it's serious, then they'll discuss it right there. But if they think it's something that's critiquing or something they don't like, they tend to not respond to it because they say we can't. So I see that, and it's so easy to see because it's on camera. So you guys want to rewind and see it, Susan and Cindy. I'm not trying to be critical, but look, you guys you're representing us. You need to listen to what's going on in this, to the people. And then I think it's, I don't know why the First Amendment has a time limit, by the way. But so anyway, I think that we need to, the county needs to apologize for what they've done with COVID. I know it's a different subject and somebody might jump in. But I'm just telling you, they need to apologize. And I don't think there's anything wrong with that. That's part of how people move on. But I want to see you guys do that. Can you guys do that, or is it too hard? Thank you.
Our final speaker on the item is Cecilia. You'll have 2 minutes to speak. The timer will start when you begin speaking.
Hello, I just want to clarify, is this on item number 5 as well, just 4?
It is 4 and 5.
4 and 5.
Yes.
Okay. I just well, on item number 5, I want to speak specifically to the report from the DA regarding the PIR program that is kind of umbrellaed under CAMP as well. Just want to thank for the continuous meetings that the DA has had with Silicon Valley Debug, and we wish to continue having those meetings more frequently. I know we missed a couple of months, but we do want to continue having those meetings because we do have we support a lot of families who are impacted by the criminal justice system and are seeking relief under the PIR program. So all I just wanted to say is we do hope to continue having these robust meetings. Thank you.
And that concludes our request to speak.
Thank you very much. And Gabby and Judge Yu, thank you both very much for your work and for the presentation today. We're now ready for the CAMP presentation. Is that coming, James, from you? Oh, from Brandon,
It's coming
of course.
from Brandon
Of
Cabrera.
course. Yes. Come on down, Brandon. It's not.
How about now?
Yes.
All right. Thank you, everyone, for having me here today. I'm really pleased to be here talking about CAMP, Custody Alternatives and Mental Health Programs Unit, on the same day that Judge Yu is here talking about the collaborative courts, because there is a lot of overlap between what I do and what they do in the collaborative courts. Let me begin by saying again, my name is Brandon Cabrera, and I'm supervisor of the CAMP unit within the District Attorney's Office, which stands for Custody Alternative and Mental Health Programs Unit. Our team has been in existence a little over a year. We began in June of last year, and we were designed to explore alternatives to incarceration, as the name suggests, but also assist in the supervision, treatment, and reintegration of justice-involved individuals back into the community who are suffering from mental health or substance abuse issues. Some of our priorities include reducing the jail population, prioritizing treatment over incarceration, and decreasing the necessity for formal convictions in appropriate cases, Doing all that while obviously considering public safety. So what I'd like to do, because this is my first time presenting to the committee, is maybe discuss some of the programs that we oversee on the camp unit and that we see in our collaborative courts. I do have a PowerPoint presentation. If I can maybe share that via Zoom. Would that show up on the screens? Would you guys be able to see that as well?
Gotta ask
If you
Colin.
logged into Zoom, I can.
Okay, great. I am
Put you
actually
up
logged
there.
into Zoom. At least I thought I was. Let me do it one more time. My apologies. There it is. All right, I believe I'm in now.
While we're getting that up, I'll just note for all dais and potential presenters, if you send your info to the clerk before the meeting, they can do it lightning fast. Perfect.
All right, there we go. So some of the programs that we do manage under CAMP, the first one I think worthy of discussion is the PAR assignment, and that's pre-arraignment representation and review. The concept here, it's a collaboration with the Public Defender's Office, and the concept is, can we get necessary information within the hands of the District Attorney's Office sooner so that we can make more decisive decisions about where an individual should be placed and what we should do? So often the public defender will go into custody early and speak with the individual and provide my office and my team information about this individual that may weigh heavily in our filing decisions and also maybe directing that particular individual in case quicker through the system and getting them into the appropriate treatment and program sooner. What we've also noticed is that we're working hand in hand with lead agencies under the PAR program. So oftentimes all that comes to our office is an issuing packet without any information about this individual's prior contacts with law enforcement or behavioral health. So oftentimes we'll receive emails or information from lead agencies and the behavioral health team about prior contacts with this individual. The idea is the more information we have, the better we can assess an individual and decide, does this person need to be in custody? Can we get them out prior to this arraignment? Or can we expedite this judicial process and get them to one of our collaborative courts quicker? As you'll see here, within the last year, there's been about 520 cases that the PAR program has reviewed. We have flagged 240 individuals, meaning those are individuals that we were aware of are suffering from some mental health issues prior to an issuing packet being sent to our office. And then my team personally has issued 144 of those cases, directing them quicker to the right programs and treatment. The goal here is to decrease the number of individuals in custody, as well as the duration of time that they're in custody waiting an arraignment, reduce those overwhelming arraignment calendars, and then also target appropriate treatment and alternative custody programs earlier in the process. The next program worthy of conversation is the YADJ program. It sounds like this committee is aware of this program, but that's an individual who, if 21 years or younger, commits a non-serious, non-violent offense, will be referred to Judge Yu's department for supervision for a year, wherein there's a specialized, personalized treatment plan put in place to address the individual's issues. Upon completion of that particular program, supervised by probation, what will happen is they have to plea in advance of being sent there, but once sent there, if successfully graduating from the program, they'll be allowed to withdraw that plea and their record will be sealed. The goal here is obviously to reduce the number of young individuals with a criminal history and to provide a more particularized treatment and services to change course and prevent future offenses. A look at the numbers here. 380 individuals of the 552 have been found suitable, and we had a conversation briefly about that recently. It is a light touch program. That was the idea when it was created. 170 individuals have successfully graduated from the program, and the current graduation rate is about 84%, which is magnificent. I know Judge Yu is being very modest, but I really think that the main reason for that is the way she interacts and engages with these individuals who are in her department. And Supervisor Ellenberg, I'm glad you went and saw that firsthand, and I encourage everyone to do that, because it's really fascinating what we do in all these collaborative courts, 60 through 62. It's very different than what you might see at Hall of Justice. And the idea there is wraparound services and providing treatment and showing that level of care to these individuals that they might not have ever seen before. And I think that's why some of these programs are so wildly successful, and it has to do with the individuals who are in those departments. The judges, behavioral health, everyone there is working together to get these individuals on the right path. The next program also in Judge Yu's department is ARC, Accountability, Rehabilitation, and Community. This is a diversion program pre-plea for individuals who are being charged with low-level felony narcotics cases. The idea here is that what we really realize when you look at it is the individuals who are committing these low-level sales cases really are doing this to feed their own addiction. And so what can we do differently? What can we do to address that core underlying issue? The idea here is you'll be referred to Judge Yu's Department 62 for, again, a year-long supervision and treatment. Very particularized to the individual. It can include a variety of things, including community service, counseling, drug testing. If you are successful again in this program, you will not have to plead. You'll be diverted. The case will not be charged. You'll be granted diversion. Roughly about 100 people are any given time within this program, and again, a huge success rate right now. About 85% are on track to graduate from this program. Of the roughly 130 that have been referred, less than 10 have picked up new cases or gone AWOL or bench warrants have been issued, and I consider that a huge success. The next big group of individuals that we oversee within the CAMP team is the mental health treatment court. So that's everything that occurs in Departments 60 and 61. That is supervision and treatment for all the mental health cases in Santa Clara County, wherein an individual is either on mental health probation, mental health diversion, or one of the local outpatient competency programs that we have in this county. It also includes Veterans Court and Developmental Disabilities. The goal of these two departments in this program in total is to obviously provide treatment over custody, a more personalized approach to supervision. It's very collaborative. None of the work that we could do in any of these departments could not happen without the assistance of behavioral health, who really takes on the assessment of these individuals, decides where they should be placed in the community, and is really the nexus between them and the criminal justice system. The goal here is also to provide really wraparound services for these clients that really, really need that level of care. This slide is just a breakdown of the type of supervision that occurs there. Again, really, it's mental health probation and all the diversion programs that we do have within the collaborative court system, as well as the outpatient competency proceedings. Here's a breakdown kind of the numbers. In mental health treatment court, there's roughly about 1,000 clients who are being supervised in some form of mental health supervision. About another 1,000 are within the programs of diversion and competency to stand trial. These are very busy courtrooms. Any given day, there's roughly 150 to 200 cases on calendar. Right now, 3 sessions a week, Departments 60 and 61 are required to share the same department. Sometimes these cases and calendars can go well past the lunch hour and past the 5 p.m. hour. 650 cases are seen per week in these departments. That averages about 2,600 monthly and over 31,000 per year. For last fiscal year, there were over 3,571 clients that were referred to the Collaborative Court Mental Health Treatment Court. That's totaling 6,455 cases. Of those, 2,000 individual clients were provided long-term services within the county. The next program under CAMP is the Forensic Mental Issues. Now that is managed in Department 25 at the Hall of Justice. This is slightly different than what we see in our collaborative courts. This assignment includes overseeing and managing many of the more acute justice-involved mental health individuals in the county. It includes the felony incompetent to stand trial population, as well as many individuals who are currently at the Department of State hospitals, including mentally disordered offenders, not guilty by reason of insanity individuals, sexually violent predators, and individuals who have been released from the Department of State hospital into the community under the supervision of CONREP. The primary goal of this particularized department is to diagnose and restore to competency as many individuals as possible so that they can move forward with their criminal cases, and also divert individuals that do not pose a significant public safety risk back into the community through one of our competency diversion programs that are then monitored and supervised in our mental health treatment courts. Here's a rough look at those numbers. At any given time, there's roughly over 1,000 criminal cases that are in competency proceedings, all of which are heard in Department 25, Judge Paul's department, and a spattering of additional cases where people are currently at the Department of State hospitals and either yearly or every 2 years are up for reevaluation of whether they belong in the Department of State hospital or not. Those are generally done by extensions or court trials to determine whether they're ready for release. Sentencing recall is another thing that we do on the CAMP team, and this is DA-initiated review of prior lengthy prison sentences that, in our opinion, no longer serve the interests of justice. This is a grant position, and the team conducts their own internal investigation into qualifying cases and accepts referrals from CDCR, the Public Defender's Office, and community-based organizations like we heard from DBUG. The idea here is, can we reevaluate individuals who have spent a significant time in prison and reevaluate, does that need to happen anymore? Have they rehabilitated? Is the interest of justice not in, do they not need to be there anymore? Can we reduce this prison population? Can we now provide a more equitable and fair sentence in line with today's practices? And can we grant release to those individuals who truly have reformed and no longer pose a public safety risk? To date, here's a look at the numbers. To date, I think the big number that stands out here is there's been 12 particular cases wherein someone was looking at a life commitment, and based on this program, we've reevaluated those individuals and they've been released from CDCR. Many of those individuals were looking at lifetime commitments. I've had the opportunity to go to the last one and watch in person as Judge Monahan spoke with the families, representatives of the community, as well as the individual. It's an amazing experience to see what can happen while someone has accepted responsibility and is ready to get out. And I think that's the job here in the initiative of, can we really look at cases where that person doesn't need to be there anymore? It is a very intense program, though. It requires a real deep analysis of that individual, what they've been doing at CDCR, victim outreach to get their input, as well as the community. The last one, I think worthy of conversation, is our mass expungement program. The concept here is reducing and eliminating criminal records that no longer need to be in existence. Can we seal, and this is done basically by enacted of recent statutes, Senate bills, or again in the interest of justice. These are done collaboratively with the Public Defender's Reentry Expungement Program, as well as in conjunction with the mass expungement projects that we're doing as it relates to Prop 64, 47, and many others that seem to be coming yearly. To date, this last year, through the expungement program with the Public Defender's Office, we were able to, actually the numbers have been updated from the end of the fiscal year. It was actually 2,700 cases that we were able to expunge or seal based on our mass expungement program and DocuSign, working with the Public Defender's Office, probation, and the courts. These were all done electronically. So no courtroom was needed, no appearance was needed. Many of these are done without the prior individual who has the conviction requesting it. What we realize is that these should be done just across the board. If an individual qualifies for relief, we're going to grant it to them. We're going to work with the courts and the Public Defender's Office to make sure that happens. Same thing with the mass expungement of 2016. We were able to eliminate 8,000 prior convictions, taking it year by year. I think the concept is to move forward now that we know it works with the Department of Justice records, to work and go back yearly to continue to do this, to provide relief for individuals that don't need to have that on their record anymore. And more or less, that is a recap of kind of what CAMP does. We have a lot of grand ideas for the future, but I think that kind of summarizes what we've done this year.
Can I just add one comment? Because I think there might have been a confusion. That 2016 number next to that mass expungement, that's people who were convicted in 2016, but their mass expungement happened now. So they are eligible for an expungement because they've served their time, they paid their fines and fees, their probation is over, and we picked 2016 as the first, as like a test year to try that mass expungement. So just wanted to clarify that that's not reporting about something that happened a long time ago, it happened just now.
That's correct.
Thank you very much, James. And Brandon, thank you very much for the presentation. I've known from the very beginning of your deep commitment to camp. And it's really fascinating to hear about the work of this unit in just a year since being created in June of 2022. I particularly appreciate the program metrics and the recap outlook structure of the report that really provided just a clear and succinct picture of where we are and where we're going. So thank you for the excellent report. I also appreciated the overview of the array of diversion programs. I was curious, though, to read in the report that says that all of the programs, this is towards the bottom of the first page, are, quote, managed by CAMP. But these programs are all collaborative. Can you explain what that means, that they're managed by CAMP, or how you're using that
Yeah, it's probably
term?
poor choice of words. I meant within the DA's office, under the we have the specialized, Jeff Rosen created this team because of all these programs that were in existence and really centralized it. So we have within the office a team now that manages, at least from the DA's perspective, these programs. But 100%, everything that I've spoken about or written about is completely collaborative.
Thank you for that clarification. And do you know, or does somebody else know, is there an overall, kind of an overarching coordinator or primary point person for all of the collaborative programs, or is that not a thing?
I wouldn't say there's a specific person that's overseeing everything, because there's really just so many things that we're doing in all those 60 departments, departments 60 through 62. Right. But I think everyone always comes to the table with the same mindset of we're working together to figure this all out. But there's not one person.
No one coordinating.
Yeah.
Okay. So you all are just coordinating your schedules and meeting.
Pretty much. There's a lot of meetings we do. There's a lot of meetings.
Thank you for that. The report also states that CAMP receives mental health referrals from behavioral health and county law enforcement agencies, and then says that if a person suffering from a mental health crisis is contacted or arrested, CAMP will be notified. What does contacted mean in that case?
Yeah, so we work with San Jose PD and other law enforcement agencies. MCAT is one of them, I'm thinking in particular. I work very closely with them. And if one of the MCAT unit goes out and maybe has contact with an individual, and they loop in behavioral health law enforcement liaison, for example, and the contact does not result in arrest, but say they've had 10 or 12 contacts with that individual over the last 6 months. Mm-hmm. What they'll do is just put a little flyer out to me, an email saying, hey, we've had a few contacts with this individual. We want you to be aware of that. And what I'll do is then I will flag it within our internal system. Hopefully that person never makes it to our office and a case is never referred to us. But if it is, I will have that background information and knowledge about this individual to make a more informed decision about what we should do. Instead of just one police report about one incident, mm-hmm. we will know about this person's background, mental health issues, and be able to make a more informed decision about what we should do with that individual and with that case.
And so a contact outside of an arrest doesn't bring somebody in. It just puts into a program or a system or any kind of expected participation on their part. It just flags.
And not always. It's a data point, right? If it's really up to the law enforcement agencies, if they just know this person could benefit from some help and some treatment, whether it's actually being arrested or not, they will let me know. And then what we can do is with the MCAT or IHOT unit, go try to meet with that individual, try to provide them services before they've ever touched the criminal justice system. And if, unfortunately, they are roped into the justice system, then I will already have all that information and be able to make a better decision about what treatment programs, where they should go. Do they really need to be in custody, or can we put them on the JAC list and try to move this along a little quicker?
Mm-hmm. Thanks. I appreciate that. A long-term goal I read of PAR is to create a specialized arraignment department for high-needs mental health and substance use clients that would provide on-the-spot and immediate assessments and services and resources at that first court appearance, rather than having to wait for a referral to one of the collaborative courts. What would be required, and I'll look at you and again also at Judge Emmety, to to operationalize this concept, a specialized arraignment court. Do you want to take it first, and then I'll turn
Sure.
to the judge?
Yeah, my thought on that is, so it takes a while sometimes for an individual to get to our collaborative court system, and that's one of the things CAMP's trying to fix. Historically, you would get to one of these collaborative court systems through either a plea, a trial, a motion for mental health diversion, argue it, and get there. Sometimes that can take upwards of 6 months or not longer. So while that's happening, no treatment's really happening, nothing's happening. We do now, thanks to Judge Yu's creativity, have pre-plea assessments as an alternative to that, and it's working quite well. But the idea for this arraignment department, and it is a grand idea, and I know there's funding issues and all the things that we've already talked about.
Okay, go for
But
it.
the
Dream big.
idea would be kind of playing in with the PAR analysis of, I'm getting all this notification information early in the process about an individual. Can we then all collectively come to the table at that first court appearance where behavioral health might be in the courtroom and can do an assessment about release and placement and planning? Reentry will be there to talk about when they're out, how can we assist them? Pretrial services will be there in case we need to have some type of additional monitoring or supervision. It's all the players at the table at that first court appearance and having a contact earlier in the process. Yes, long-term it would require its own department and staffing, but we're working honestly right now on a proposal to maybe have a pilot program work where we could use pre-existing arraignments that happen every day, maybe 1 hour a week of that, and try a few cases with this concept to see if it works and build upon it. But that's the idea. The general concept is, and you're going to hear me say that over and over again, is can we get all the right people in communication, in contact with the individual sooner so that we can provide services sooner?
Judge, you literally rising out of your seat.
No, we are, like I said, we are all very collaborative, and she knows better, so.
Go right ahead.
I think it's so doable because we used to do our own drug arraignments at FJCC, but we didn't have all the services. So then those arraignments were moved to HOJ, but it's definitely doable. And I would sign up to be that judge because
course you
it
would.
would just be so great. And maybe I wouldn't want to retire. But we did it before, but we didn't have the services. So if you put those arraignments back, now we have the services, it would definitely be doable. Thank you.
Thank you. And again, ideally, this should be how arraignment works, right? Rather than limiting to specific cases. How do we think about just iterating the general broad arraignment process? In your vision, services would be provided at that first court hearing. We'd immediately release a person to treatment. Of course, then we're back to the housing and the availability of treatment there. Casey, Casey and Sylvia?
Yeah, I just wanted to mention that we've already begun discussions between administration and representatives from the Public Defender's Office, also from the District Attorney's Office and Pretrial Services, on what that proposal would look like for a pilot program. So administration is very excited to work on on this project with those departments.
Cool. Go ahead.
You know what? I actually thought PAR was the pilot. I mean, to be honest with you, that was part of the reason we.
Right. Isn't that pre-arraignment, though?
Well, yeah, but the idea being that, to your point, just making sure that we were talking to people at the earliest possible time, and we see that working. So I'm more just, I'm saying that I hear what you're saying, Judge Yu, and think that makes a lot of sense. And Brandon.
Sylvia.
Yes, so good morning. So, one thing is, these programs are amazing, and the DA's office needs to get a lot of credit for their creativity and their effort to implement these diversion programs that are so desperately needed in our county system. And I think the takeaway from our conversation this morning is that to do these programs well, it takes a lot, right? It takes the big sort of coming together of a whole bunch of systems, greater collaboration, improved communication, and really good coordination of services available. I guess and I don't want to be the Debbie Downer here, because I'm generally very optimistic, but I think when we look at all of this from a big picture perspective, this is just a drop in the bucket in terms of the need. And I absolutely want to focus on the expansion of the current models in the current programs to the extent feasible and possible, because one of the drawbacks of all of these models that we have right now is that it's right now excluding a very significant number of people. ARC, for example, I absolutely cannot wait until we can expand it further, because right now only the very select few who have the luck of being represented by the Public Defender's Office is participating in that. So we're not, so we have some ability to expand it, and then be able to expand it to a way that we're adding more people that can benefit from it. But I guess the big thing that I would like us to think about, and it goes to your point, Madam President, about how do we get services to people without having to create a very linear and narrow path to that service being received. Because right now we have mental health treatment court, and we have wait lists, and we have a very large volume of calendars and cases waiting there. We have people waiting to get treatment there. The pre-plea assessment is available and is helpful, but we're waiting for assessors. And so I think the better approach would be, if we are going to be thinking about this sort of more unique style of arraignment and providing services at the arraignment, is even think broader. Like, how do we empower all judges who do arraignments to have information at their fingertips about what to do in the event they are arraigning a mentally ill client or a highly addicted individual? Because if we don't think broader than the sort of narrow boutique model, we are missing a lot. And I applaud it, I want it, and this is wonderful, but if we're going to have bigger systemic change, we need to think bigger.
Thank you. I'm going to go to Damon and then the sheriff, and I bet that's the first time you've heard the Public Defender's Office referred to as boutique.
It's kind of nice. Thank you, Chair Ellenberg. And Sylvia, I agree. We want to broaden the net as much as we possibly can. We've already discussed it earlier today, just in the context of YADEJ, and how do we capture both in expanding age, but really thinking about expansion of charges that are eligible, and get as many of our youth or recently exiting minor status into that particular system. I want to thank Brandon for your presentation and the leadership in your new position at the District Attorney's Office. I think it really has spoken to the collaborative nature that is in some ways very unique to our county. I mean, certainly we all understand, and James, you know that there are periods where we are going to be in disagreement and we're going to be adversarial, but we are always looking for opportunities where we can really be collaborative, and I think this presentation touches on a number of those. And who's doing the heavy lifting and what agency is a leader or takes the point position may shift on program to program, but none of it actually succeeds without the collaboration between the District Attorney's Office, the Sheriff's Office, certainly the Probation Office, and in particular the court as well. So we really work in a wonderful collaborative way. I had two observations I did want to share. One in particular to the forensic, the forensic program, and an issue that we're seeing at the county that probably needs to be addressed at the state level, which is we spend many months sorting out the competency status of clients, whether they're competent to move forward with trial. We're declaring a declaration in court that we believe they're incompetent. It leads to a lot of expensive evaluation that the court has to invest in. Oftentimes we're investing as the public defender in reports, or the defense community. Sometimes it results in contested litigation. It takes months that these individuals are sitting in our county jail, and ultimately a conclusion is that they are incompetent and need traditional services provided at the state hospital. The state hospital for the last couple of years has been sending evaluators to our county doing an evaluation with zero treatment, zero resources, and concluding that this individual is restored, and in essence setting us right back at the beginning of the clock. It is, in my opinion, unconscionable. It is a waste of our money and our resources. And I think collectively as a county, we need to think about how we address this issue at the state level. That's one observation I'd share. The second observation I would share involves the resentencing and recall efforts. And I really appreciate the efforts that the district attorney has taken in one lane of this, which is the prosecutor-initiated recalls. And in fact, they've worked very closely with our office in us flagging, and we can see that expansion happening. But there is already a high level of recall work and resentencing work going on. I mean, we are just still tackling the prison prior reform that is supposed to be completed by the end of this year, that we all collectively agree that we have not had the bandwidth to complete. But we have other recall initiatives coming down, and really what I would describe as a little bit of a tsunami and a perfect storm heading our way, which is we have veteran recall efforts coming. We have the Racial Justice Act that is expanding to retroactivity, which means we have close to 2,000 to 3,000 citizens or county, former county residents in our state prison system that we're going to at least have to evaluate for relief under the Racial Justice Act. Not that all of them are going to get litigated or ultimately result in a court hearing, but we need to figure out how to triage this. Right now, as the Public Defender Office, 2 of our post-conviction positions are related to a grant that is going to sunset at the end of FY 2024. So in June, we will likely lose 2 of our positions. I believe the district attorney has their recall position based on a grant. So we are both looking at a tsunami of additional work coming our way and the possibility of losing these positions. And I just put that on everyone's radar. We have a lot of work to do and need to think and understandably strategically from the county's perspective, knowing where the budget sits, but think about how we're going to tackle these issues moving forward.
Sheriff Johnson and then Judge Emity.
Really briefly, first I would also like to commend the District Attorney's Office for their work around this area, especially the various programs. And where my attention was drawn initially, especially to the sentencing recall, is when you started this work, about a year ago, I believe it was, the District Attorney Jeff Rosen held a town hall or a forum that actually highlighted and spotlighted 2 individuals that were part of that initial recall. And at the time I was the chief of Palo Alto, but what struck me was that both of them, these individuals that had their sentences recalled, talked about the importance of programs and access to programs, and they wished they had had access to those earlier in the system. And the reason I bring that up and the value it has for our county, I believe, is we are, even though a vast majority of the work is being done before they come into our care, the reality is we have a population of sentenced individuals. Now, granted, most of those individuals are for the nonviolent that stay in county jails, because Prop 47 really revised a lot of that. Prior to Prop 47, the county jail would only house somebody for really up to a year. But after Prop 47, we now can take that individual, sentence individuals sometimes for multiple years. And the reason I'm bringing this up is it seems like you have the system in place. So my question to you, and I somewhat apologize because I haven't learned all the nuances of the county system in my 9 months yet. But my question to you is, vast majority of the focus right now is on those state sentences. But is it possible to start really looking at those that are sentenced, doing their terms in a county jail, that have actually gone in a very similar approach that those 2 spotlighted prisoners talked about? Because I have Dr. Marshall here and Lieutenant Gill, who are very active in our college collaborative, which I'm very proud of. But if they take that initiative from the moment they come into the system and want to change their life, and they commit to it and they enter the programs, they get educated, whatever it may be, and we show that individual 2-3 years in, maybe an 8-year sentence, they've really rehabilitated. Could we now use your structure to have their sentence reevaluated for potentially taking advantage of the things that they've learned to release them back into our communities?
I think that's an interesting idea, and I think the answer is yes. I think we could. The current position right now is a grant position of one DA reviewing these things, so he has well over 100 some cases that he's reviewing, and the focus is on the CDCR long-term commitments because that's where we saw a lot of the movement needed to occur. People who were doing significant time, 25 to life, heavy sentences that today would get nothing similar to that based on the same charges, and we felt that was where the focus should start, but by all means, I think across the board, the DA's office and my team and me in particular are interested in expanding all these programs. And that's something I've never actually thought about, the local commitments. We had a few there that were done because of prison priors or what have you, but I think that's an interesting concept that we would absolutely look into. Our entire philosophy is that someone who may have done a sentence or be doing a sentence who has rehabilitated should have the opportunity to have someone, my team, look at that. And I think that's an interesting idea. So yeah.
Thank you.
Judge Emity, then Judge Yu. You raised your hand, yes. Okay, Judge Emity.
So early on, when Judge Yu was speaking, you asked, what could we do to make all of our courts collaborative and have. I agree and support that. And so in a perfect world, and a little bit along the lines of what Sylvia had to say, if we had these resources in each of the arraignment courts, if we had a substance abuse assessor, if we had a mental health assessor, if we had victim witness services, if we had in each arraignment court, I would love that. I would agree that it would help us to better serve everybody in the system. Our reality, I think, is that there aren't enough assessors, there aren't enough victim witness people, there aren't enough. And even if we did all of those assessments, there aren't enough beds to send all those people to, right? And so, I mean, if I were queen of the world, I would make all of that happen, but we have to have the infrastructure that would support it.
You could just be a supervisor and not queen of the world. and you're right. But I don't want us to stop and say we can't do it because we don't have all the things. What we have to do is know what all the things are and have a strategic plan that's implementable over time to put that all into place so that we can get there. I think that it's critical that we not let the fact that it may not be doable today prevent us from really and I'm using the word strategically, intentionally, so that we are talking about what are the goals, what do we need to get there, what's the workforce, what's the funding, what's the space, what are the beds, and how do we achieve that? So thank you for that.
And I agree with that. And we have, I mean, if you think about it, and you all, DA in the Public Defender's Office can tell me if I'm wrong, but on any given day, we're doing arraignments in one misdemeanor department, one felony department, and one domestic violence department. We're talking about 3 departments, right? So it is not as insurmountable as it sounds, as long as that there are then resources we can send people out to. And then Judge Yu is saying that she also would be, right? So I mean, I think that it is not undoable, but we have to, at the end of the day, have the resources where people could then take advantage of it.
I'm going to interrupt the flow just for a quick minute for exciting housekeeping details. Which is that we in no way adhered to my idealized schedule. So thank you for that. So I'm going to ask that items 8 and 9, we move to our next meeting with apologies and hopeful understanding. I know that our rehabilitation director and the Office of the Sheriff wanted to make presentations. I'm afraid that even if we accept them without comment, we're still going to run up against the 12 o'clock. And we will hear item 7 after 5, the Commission on the Status of Women report. I know we've got folks waiting for that. And then if we don't get to 6, do we need to hear 6 and 7 together? They were to 7? They're separate. We'll do 7 next, and then I think we may be out of time. I want to be respectful of everybody's calendars, so we may need to move 6 as well. Let's see if we can do it. Judge Yu, then Matt, and then we'll move. Go right ahead.
I'll be quick. First of all, if we were to start somewhere, when we did all the arraignments at FJCC, they were basically the drug cases. So it could happen it's starting somewhere. And then what Ms. Perez McDonald said is kind of a reflection of the fact that we're really new in these things. We're just starting them, but I would say these are not boutique calendars. ARC has representatives from the Public Defender's Office and the ADO and private attorneys. For the first time ever, we actually had a YADEJ calendar where the public defender had no clients on it because there were so many private attorneys who had clients on it. So these are all just sort of growing issues. And then just to share, this governor and the past governor have been appointing really forward-thinking judges who want to do this work. And Judge Emity and I have taught together, and we actually have judges take the ACEs test and take a emotional intelligence test. So I think that these things are definitely possible where every courtroom would have a collaborative court model or mindset, because that's what I teach too. It's just that, we're in a process, but it's definitely something where we're leading it in Santa Clara County, and it's all super hopeful.
If I could just build off that, I think Judge Yu is 100% right. And I think the reason 85% success rate in her 2 programs and departments is because she has the ability and time and the energy to sit down and talk with those individuals face to face. Spend a minute, sometimes 5 minutes. They have a back and forth. How are you doing? How's life? Just actual conversations. That can't happen in every other department because there's 200 cases on. And we can't have that individual engagement that she's able to have. So we are expanding YADEJ. We are expanding ARC. Trying to, but in a particular way that it doesn't ruin what we already have in place that makes it so successful. And that's why you're going to hear me say what we really need is more departments. We need all 4 departments open so that we can spend that time with those individuals, make sure that we are connecting them appropriately with outpatient program and treatment, assisting them with it. I think that's how we encourage them to be successful. That's how we get them not to come back in the system, and that's how real change happens. My concern with the reason I think the arraignment program should start as a pilot and small and just for this same universe of people is because we work well. We know it's already working. These arraignment calendars that are only 3 of them a day have about 80 cases on themselves. So I would love in a perfect world to have an assessment for everyone and all those things, but then these calendars would run till 8 p.m. at night, right?
Got it.
So
Thank you.
It's managing it all, but I think everyone's on the same page about how to do it.
Thank you very much. I'm going to give Matt the last comment on this item.
This is very quick. Thank you, President Ellenberg. Judge Yu and Brendan said it very well. I think because we don't have all the resources and we don't have them in the same place at the same time, all the more reason to strategically put them up front. It may not be the first day. The public defender and others might need a day or 2 to have the right information and make a move, but it really does avert unnecessary court hearings and lag time in between to do that. So,
thank you very much. Supervisor Chavez, did you want to introduce a motion or receive this item or just move on?
I think we would just add this to the motion that was already made because we didn't vote on the other item. We took public comment and then went to this item.
Thank you.
So what I would just say is we should receive the report, but what I would also recommend is, and part of the reason I wanted to hear both items together was because I think that a number of the ideas that came up here, when the staff sits down together, you should take a stab at prioritizing what you think is possible for us to incorporate, especially as we're looking at where we're already going to expand, where we need to expand staffing already. And then one request, Judge Yu, that I want to make is that I'm very interested in the national research that you referred to regarding drug treatment and how, where we see more success. And I'll hold because I know we have a lot of other issues. And when it comes back, I'll make sure that I have an opportunity to weigh in.
Thank you. That's, of course, fine. The last piece that I'll add is direction to administration to begin thinking about what a real strategic plan for this would look like. Think about, we know what the vision is. We know what we want all of our courts to look like, how they want to be staffed. And if we work backwards from that vision over time, what do we need to build towards so that we can see that? And I don't have a specific date request. I know we're doing a lot right now, but certainly within the next 6 months or so, I'd like to see that. And again, it's a piece of the way in which the county as a whole needs to really be working and thinking about strategic goals in all of our priority areas, and we'll start a county-wide process for that in January of 2025, but I don't want that to hold this one back.
So I think 6 months is fine. I'm assuming you would want it before budget.
Ideally, absolutely. Thank you. All right, let's vote on this item, Colin.
Vice Chairperson Chavez.
Yes.
And Chairperson Ellenberg.
Yes.
Motion carries. Thank you.
Thank you very much. As noted, we're going to move to item 7 to hear the Commission on the Status of Women's Public Forum report. And if we're very expedient, we will get to hear item 6 as well, but that remains to be seen. No, I know. And Jennifer, that was not an indication that you need to be expedient over substantive. Happy to hold the other item. And turn your mic on, please.
You can hear me? Yeah, thank you so much.
Benayafar, sorry, I said Jennifer. I'm so sorry. Benayafar, please.
Yes. I'm Benayafar. I'm the chair of the Commission on the Status of Women. This is about a public forum that we had for justice-involved women. And so the report that we have made, the commission, that I presented on behalf of the commission, it's pretty exhaustive. And I'm here not to speak for the women, but just convey the voice and the needs of the women that we heard. And it was over and over the same things. I feel such a sense of gratitude and appreciation for these justice-involved women who came forward, gave their testimony, talked about their experiences and needs. It was very powerful hearing their testimony, at the same time very painful, because these women are mothers. They have families, the impact of incarceration in and out of custody, the needs that they have, or the unmet needs, how it impacts them, how it impacts the recidivism, was powerful and painful to hear. And today, while hearing everybody, I really want to acknowledge the efforts that are being made. Everybody is doing their part. I could sense that. But we could also, all of us, sense that the need is still greater than all the things we are still doing. We need a lot more resources to be poured in. And so that's what I think what the women conveyed was exactly what every component or every program that discussed about. What we hear in the report, or what we heard from the women, is exactly the issues that everybody discussed. And so I think we all need to pitch in. We all need to gather the resources, get every possible collaborative effort at every level to meet their needs. And so I am there to answer any questions on the report or on, yeah.
Thank you very much. Do we have public speakers on this item?
We do have one request to speak on Zoom.
All right. Reminder to folks on Zoom, if you're intending to speak on this item, now is the time to raise your virtual hand. The queue will close when the first speaker begins speaking.
All right, we now have...
Let's give them a second.
We currently have 3, 2,
Oh, there you go.
3. We have 3 requests to speak.
All right, if we're holding at 3, let's go ahead and begin.
Yes.
Thank you.
The next speaker is Raymond Goins. You will have 2 minutes to speak. The timer will start when you begin speaking.
Good morning. My name is Raymond Goins. I'm with Silicon Valley Debug. First and foremost, I want to say, Ms. Perez, I never got to thank you for signing off on everything that Brian McCummins did to get me home when the district attorney office opposed my resentencing when I was recommended by a CDCR to come home. I appreciate everything that you did and you allowed Brian to do for me to be home. If it wasn't for you, I wouldn't be home. My issues with the DA's office and the PIR, prosecutor initiated resentencing. All the resentencings that I've seen done in county jail since I've been home, and with my own case, the prosecution has opposed them, adamantly opposed them. I had the prosecution, the DA, tell me that I was an animal and I was unfit to come home. I was unfit to come to society. So I don't think the district attorney's office is well equipped for PIR because they're not implementing their own rules. they have a small set of criteria that they exclude a lot of people who should come home back into our community, who's best fit for our community. I'm a violent offender. I was a level 4 inmate, and my prison record wasn't squeaky clean. But yet I am free. I'm here in society, and I asked one district attorney, is society best served with me being in prison or me being free? And the answer was, Raymond, it's with you being free. And it's like, it's crazy because not even 3 weeks ago, or not even a month ago, you guys were saying opposite. You guys were saying that I was an animal. So I think that the county needs to look at how the DA's office, our DA's office, is what they're telling you and what they're actually doing are two different things. I've requested the numbers of PIR from Susan Champion, who the DA's office works with. And Ms. Champion says that the DA's office has only requested a limited amount of cases to be reviewed for PIR. And that's what I got to say about that.
The next speaker is Adriana Jansen. You will have 2 minutes to speak. The timer will start when you begin speaking.
Good morning or afternoon to the board. My name is Adriana, and I'm a program manager at the Young Women's Freedom Center. I am calling in to support item number 7. Young Women's Freedom Center was present in providing recommendations to the Commission of Status of Women back in May of this year. Through the day-to-day work we do at the Young Women's Freedom Center supporting incarcerated young girls and gender-expansive youth, it is clear to us that the conditions of the justice system do not provide living conditions for young people to grow and are limited in expansive gender-responsive programming. The report created by Commission on Status of Women highlights the current struggles and current access to resources such as employment and community-based reentry supports that youth currently receive while incarcerated in Santa Clara County juvenile facilities, such as, and not limited to, the juvenile hall, branch facilities, and transitional placement programs. Young Women's Freedom Center trusts that the board will address this and consider the recommendations outlined in the report. Thank you.
Our final speaker is Blair Beekman. You will have 2 minutes to speak. The timer will start when you begin speaking.
Hi, Blair Beekman here. Thanks a lot for this item. I've never heard of this work before, and it sounds really interesting. Thank you for the first public comment person who, like myself, Santa Clara County women and their leadership in issues, they're practicing so well and so good that, I want to bring my cases of justice to this item and this body. So thank you for the work as women that you do in Santa Clara County to address justice overall, that I think has can have a real important woman's voice in how to address our issues that I actually tend to try to follow most. So thank you for that, and thank you for wanting to address things like the DA's office. That tends to be a more male-dominated office. Good luck how to address those sort of concepts. Thank you.
That concludes our request to speak.
Thank you very much. Benifer, I know there was a recommendation for the Commission on the Status of Women to be engaged in the gender responsive work that's being led by the Moss Group.
Yes.
But has that occurred, or is there a timeline in place for when that engagement will happen?
So we are not aware of the meetings or invited to the meetings, or if they have started. So we would definitely like to be a part of the gender responsive work of Moss Group, because I remember the Moss Group actually interviewing us jail monitors, because we used to go to the jail, and that program is on a pause since 2020. So they did take our input while making the report, but after that, there has not been our involvement. So we would love to, maybe the work is in the beginning, I don't know, beginning stage, but we would love to be involved in the meet. Yeah.
Thank you so much. Then I think what we're going to do, are there other questions on this item? Yeah, please.
I have two. So first, I want to say thank you also, and I would hope if we could, just to make the connection relative to the Moss Group issue now, because I think, Sheriff, you have staff here that's engaged in that.
We do, and that was going to be, I think they were going to talk about that in item number 6.
Item 6.
Yeah, and I think very simply that the request would be, can we make that connection and engagement.
Yes. So if we are invited, we would send one of our representatives. Sorry.
So let's hear, yes. Go ahead, Laura.
Good morning, everyone. I'm Captain Rita Rowland, to Supervisor Ellenberg and Supervisor Chavez, and to this esteemed committee. Want to say that we did have a tour that we invited the Commission on the Status of Women to tour our jails because we had not had a connection for quite some time. We've had that, and we have looked at some items from the gender responsive recommendations for them to help us with. And right now we're in our strategic planning, and part of that plan is to have them to assist us with.
Thank you.
So I'm hearing that they will be invited to future meetings for the strategic planning and all of the other work that's happening.
Yes.
Excellent. Thank you so much.
And then the only other thing I wanted to follow up on is that there were some recommendations that, again, I think this is a topic I think we need to agendize for a future meeting, but one of the concerns that was raised was when we're letting women out of custody, and I know we have had issues relative to people who are mentally ill, and so I would, through the chair, like to just request that we pull that discussion off for a meeting, for an item here, so we can talk about the best way to be strategic about that. And we've kicked that around. And honestly, Sheriff, we hadn't had a chance to have a deeper conversation with you about that yet, and with the courts.
So item 6, do you want to come back specifically, or do we want to receive this item 6 report today and agendize a separate conversation?
I want to agendize a separate conversation for this issue about when folks are being released from custody.
So the late night release program, the late night release conversation does come up during the reentry network meetings.
Right. The reason I'm recommending that it come here is that I think that the board is going to have to make some decisions relative to that are aligned with some of the issues that are already on this agenda. So I do want to just ask that through the chair, and what I'll recommend then is through the chair and the staff that we choose the appropriate place to have that conversation.
I'm happy to do that, and I'm looking at Kavita because we've sort of bled into item 6, which means that we need to have public comment on it and receive that report. So I am going to do that. We will accept the report, which is in writing. We will agendize further conversation, but let me get to Colin. We're going to now hear public comment on item 6, which is the gender responsive work in custody settings report. And for those of you who are members of the public listening, the report is attached in the agenda. We're not going to discuss it today, but we are going to receive the report. Do we have speakers?
We currently have one request to speak.
All right, let's hear our single speaker, please.
All right. Next speaker is Blair Beekman. You will have 2 minutes to speak. The timer will start when you begin speaking.
Hi, Blair Beekman here. I wasn't around for all of the item yesterday on what to do about the police spray issues in cells. I'm sure transgender community has to deal with that issue a lot. Good luck in whatever you had to work on yesterday. It was a difficult subject that we can improve upon it as we move forward with it. And I just think in time, thank you for bringing it to the public process yesterday. I think with time, we can really better and better address it. So thank you for that, and how I hope transgender rights can be appreciated and respected in its instance and for this item. Thank you.
That concludes our request to speak.
Thank you very much. I'm going to ask for Javier to speak.
Yes, just quickly. So this year marks the 50th anniversary of the start of mass incarceration. So I really want to commend the Commission of Status of Women on bringing this report to us, to highlighting the harm that our system has done for countless women. And I'm very, this report really brought the attention of the lack of health access, treatment, and housing. And I know that's something that we earlier discussed. One thing that there was a recent article on the Transitions to Clinic Network where our medical mobile unit goes into custody to start working with the men and women in custody. So that's something that I'm wanting to ensure that we continue and expand. The women that you interviewed and the women that you serve both in the community and in custody are individuals that come to the reentry center. And we looked at the report of the 382 clients that came to the month of August. Only 69 were women. So we have to do better in making sure that more women are accessing our reentry services at the center. And also, I think one item that you brought to this in this report is removing barriers for peers to access the custody. And I think that's something that we're working very closely with the Sheriff's Programs Unit to ensure that a lot of our lived experience staff hired by the county and lived experience community advocates are able to talk to the women in custody. So again, on behalf of the Reentry Center, and I know some of my staff participate in some of these meetings, but I look forward to continue working with the Commission of Status of Women and the Office of Women's Policy. Thank you.
Thank you.
Thank you very much. We can do a joint motion to receive the reports in items 6 and 7.
So moved.
Seconded. Let's vote on that item, please.
Vice Chairperson Chavez.
Yes.
And Chairperson Ellenberg.
Yes.
Motion carries.
Thank you very much. And with apologies on the timing to the Sheriff's Department, we will move items 8 and 9 to our next meeting. Are there any announcements from anyone on the dais? All right, then we stand adjourned. Thank you very much, everyone.
Thank you.